Slavery is back.
Welcome to a place where private business profit from a captive labour force, yet pennies are spent on medical services to a population in which the Indigenous, the poor and the mentally ill are overrepresented. Where isolation, humiliation and degradation are facts of life. Welcome to prison.
It depends who's telling the story, I suppose. The prisoners would have one view, the people who work in the prison system would have another, and I think it's up to people to decide where the truth is.
Give government propaganda and the media spin doctors the flick. And check out Doin' Time for news, views and tunes on prison issues from Guantanamo Bay to Christmas Island to prisons and detention centres everywhere. Every Monday at 4 p.m. on your community radio 3CR.
We are still fired up and we're still talking about revolution.
Hello and welcome to the Doin' Time show. This is 3CR Community Radio, 855 AM on the dial, streaming live on www.3cr.org.au. This is Marissa and I will be taking you through until 5 o'clock this evening. Last week, we spoke with Dr. Tamar Hopkins and we will be continuing our discussion today. But before I launch into specifics, this episode of Doin' Time contains audio images of Aboriginal and Torres Strait Islander people who have died and discussion of deaths in custody. So we spoke with Tamar Hopkins, who is the lead researcher of a report that was released a couple of weeks ago entitled Policing COVID-19 in Victoria, exploring the impact of perceived race in the issuing of COVID-19 fines during 2020. And this was a project of Inner Melbourne Community Legal Centre. So today, Dr. Tamar Hopkins is going to be our feature interview and our only interview, and we're going to be speaking with her quite specifically about her thesis and the background to racial profiling, and I'm going to be handing over to her very soon. Hello, Tamar. Welcome to the program.
Hi, Marissa. Thanks very much for your interest.
It is lovely to have you. And it's not just about interest, Tamar. It really is about necessity. It's a very, very important topic, and I see this as a landmark thesis to stop racial profiling in Australia, specifically Victoria. Can you talk to us about the thesis? Is it a thesis or a PhD or both?
Yeah, it's both. It's a PhD thesis.
Wonderful.
So, yeah, I can. And I may as well start by giving you a bit of background into why I did it.
Yep.
Yeah, so as your listeners might know, I started my kind of interest in this area through working at the Flemington and Kensington Community Legal Centre and being confronted by the most horrendous stories of police racism and violence towards African and Afghan young people in that area, and started doing a whole lot of things like running criminal defences for those young people, submitting complaints, running a big race discrimination claim against the police that settled in 2013, and just a whole series of legal activities. And during that period, I became really aware that Australia is really missing some key pieces of evidence about racial profiling that exists in other parts of the world, and certainly doesn't have an advanced case law that lawyers can rely on to show racial discrimination has occurred. These things just have not been litigated in Australia. People are not bringing cases, and there isn't kind of an evidence base. There is a lot of evidence, qualitative evidence about discrimination. A lot of stories, cases, people talking about discrimination, but we don't have that quantitative evidence about, really showing that the experience of racialised people, in particular racialised groups in particular, are worse than white people. And so, aware of this gap in evidence in Australia, I decided, okay, it's time to go out and try and collect evidence to explore whether there is evidence of racial profiling that can be obtained here. And so there is one of the reasons that we have this gap in Australia is that police do not collect and release data on their activities in a routine way that allows people to kind of track what is going on. And this kind of data is available in the UK, many parts of Canada and the US, but just simply hasn't been obtained here in Australia. It hasn't been released by police. Victoria is the only state at the moment where police even collect data about different racialised groups. Other places have data by First Nations and white people, but really only very, very limited forms of data, not data that could track the targeting that police can engage in against these communities. And so what I did with this PhD, I did two things. I started a process of doing FOIs for police for data, which ended me up in years of litigation in VCAT and wasn't getting anywhere. I am finally now getting somewhere with that approach. But instead, realising that I wasn't going to get the data I needed that way, I decided to take a different approach to gathering data, and that was to run a survey of the Victorian population to track their experiences with contact with the police. And this was a survey based on a strategy that had been applied in the US in Kansas City by a group of researchers, Charles Epp and others, who were exploring racialised differences in police treatment of people there, and came up with this strategy of doing what I've been calling a threshold test to test whether there's racial profiling in data. And so I thought, okay, let's give this a go in Victoria. Let's see what we can find out based on people's stop experiences. So what I did was I did a survey, an internet survey. So it had 77 questions, an online Qualtrics survey, and that survey was advertised across Victoria in a number of ways. So it was advertised through the Facebook sites of the Flemington and Kensington Legal Centre, the Federation of Community Legal Centres, through Aboriginal Legal Service, and through the Asylum Seeker Resource Centre, and distribution of 1,000 postcards throughout Victoria to libraries with their website where people could go, and also through this radio station. So I did a card advertising the survey on 3CR to get it out to as many people as possible. And so as a result of that kind of promotion of the survey, 981 people responded over a period of 5 months to that survey. And I asked them, the first question was, what was their racial background? And then secondly, if someone was to see them for the first time, what would be their best guess as someone else, how someone else would describe their racial background? Because what I was really interested in was not people's actual racial background, but the way they might be perceived by a first-time observer, because that's the essence of racial profiling, is what those impressions that police have of the people that they go past on the street or in cars. What is their impression of their racial background? So that was the key kind of variable in the survey. And then I asked a series of questions about their most recent stop by the police. What was the reason that police gave them? What happened? And people were asked to give text box responses and tick box responses to all of those questions, and this produced a very kind of rich database of information about those police stops. And so what I was able to do was go through and have a look at the reasons and compare them with the legal justifications that police have for stopping people in Victoria, and whether there was some kind of reasonable basis for their decision, or whether it was just a stop that didn't have a basis. And so, for example, in Victoria, it's possible for the police to stop people to do a licence and registration check or to do a preliminary breath test without any basis at all. So while that's legal, there's no underlying offence that the police are witnessing before they decide to stop that person. And so I was really interested in where are there any racial differences in who is getting stopped in this proactive way. So it might be technically legal, but it's a proactive stop that doesn't have like an actual basis behind why the police are making that stop. They're just going off on their hunch, their sort of, spidery sense, their sort of generalised sense of suspicion as to who to stop for these kinds of stops. And so what I was able to do then was have a look at the differences in terms of, the racialised, perceived racial background of those people and how the police were treating them. And what the survey, the results from the survey showed that there were very different responses that people were receiving. They were getting treated, the police were treating people quite differently depending on their racial background. And so, for example, racialised people, so this is everyone who is not white, compared with white people, were being stopped for this proactive high discretion stop compared with a low discretion stop. So that would be a low discretion stop is where the police witness a traffic offence, a serious traffic offence like speeding or going to a red light. So when you compare these high discretion with low discretion stops, racialised people had an odds ratio of 2.8 times more likely to be stopped for these high discretion stops than low discretion stops than white people. And the evidence for that was very strong. So the p-values were for that statistical test was under 0.001. So it was a very clear finding that racialised people were being treated differently to white people in terms of those proactive stops.
So basically what's happening here is that the thesis demonstrates that Aboriginal and other racialised people are more likely to be subject to these types of humiliating experiences than white people. That's right.
So there was a range of experiences that I was able to test. The main one was this difference in stop type, so proactive versus actually having a reason. And so I was just giving you the figures there for all racialised people, but particular groups of racialised people, and I looked at specifically at Indigenous, African, Pacifica and Middle Eastern appearing people, were even the odds for those people being subject to to proactive stops were even greater than white people. So it was even starker. The difference was even starker in the way the police were treating people in those particular targeted groups. So that was quite a staggering finding. But there's even more than that. So the study was able to look at, once someone has been stopped, what happens then to the person? And in vehicle stops, the treatment that the police were giving people was more likely to be unjustified, so there wasn't a specific reason for what they were doing when they were, after they had stopped a targeted racialised person and a racialised person than a white person. So again, we were seeing really big differences in the way the police were policing targeted racialised groups to white people. So here we had, really clear evidence that the police are operating. There are two systems of policing in Victoria, and that one, there is a kind of a more textbook version that the police roll out when they are policing white people, and there is this more kind of speculative, invasive and humiliating type of policing when police are policing particular racialised groups. So it's really clear evidence from that data. And if I can just go to a few more data points.
Yeah, please.
It's just quite kind of disturbing. So while I was looking at particular types of experiences that people had and just comparing, are these more likely to be experienced by these targeted racialised groups than white people? And I was able to find that the police pulling up beside a vehicle, like as they're driving along, and they come and they sit the vehicle next to that person, next to the vehicle, and look into the car, that Indigenous, African, Pacifica and Middle Eastern appearing people had 4 times the odds of having that kind of experience with police than white people. And that particular group of people had 9 times the odds of police calling for backup before they actually spoke to them. So they'd pull over the person or put the lights on, the sirens on, stop their police vehicle behind them, and then call for backup. So you'd have kind of a whole lot of police cars coming. And so these racialised groups had 9 times the odds of police having backup, calling backup when they did a stop. There was also these particular racialised groups had 4 times the odds of their passengers being questioned by the police. So, that's just extraordinary. And 13 times the odds of having their passengers asked to leave the car, twice the odds of the driver being asked to leave the car, and twice the odds of drivers being asked why they're in a particular area. So you can just start to witness these kind of totally different investigative strategies that are being rolled out when the police are stopping, doing particular, intercepts with targeted racialised groups compared to white people. So, yeah, very disturbing to kind of get this evidence. We know people have talked about this. There have complaints been made to legal services, Aboriginal legal services, just in general about this kind of difference. But here we have, statistical evidence of these clear differences rolling out. So,
absolutely. And during your introduction, actually, you speak about an Aboriginal woman who was pulled over by the police, and the police were quite degrading to her. There was a lot of unjustified police investigation. And what I found interesting there is that you talk about the fact that the thesis demonstrates that there's really isn't a lot of external scrutiny of police. Is that accurate?
Yeah, that's
very
right.
accurate, isn't it?
Yeah, so that's right. Well, what happens is that these stops are carrying on every day. So we know that the police have in fact told us that they have about 14,000 contacts with the public on a daily basis. And these stops, these results are showing that the stop types are very different and the experiences are very different depending on people's racialised backgrounds. And yet what we know is that these stops aren't subject to any kind of scrutiny. They're barely internally scrutinised, let alone any external scrutiny. And so it's just kind of laughable to think that there's any, when police deny racial profiling, it's just like, well, you're not even looking at what you're doing, let alone, how can you possibly deny you're engaged in racial profiling? So it's very disturbing that these kinds of encounters happen on a kind of a routine basis, and yet there is nothing that is being done to monitor them.
Nothing at all. There's such a lack of transparency in Australia, isn't there, about who, how, and for what reason police subject individuals and communities to investigation. And I know that I've interviewed you quite a few times pre-pandemic, many years ago, and the same thing is still happening, and there doesn't seem to be a lot of improvement here on how to monitor racial profiling. There really doesn't seem to be a lot of data here that is correlated. So this thesis is really useful.
Yeah, that's right, absolutely. And I guess what it really points out is that, the Hale Michael case that settled, this was that case brought by a group of African and Afghani young people, settled in 2013, and the police responded to that settlement with 2 public inquiries into their field contacts and multicultural training, and set up a whole new department, the Priority Communities Department, that was meant to deal with these issues. And they, in 2015, introduced Australia's first anti-racial profiling policies. But what this thesis shows, this data that I have here is from 2018, 2019, so 4 and 5 years after that policy, is that no, racial profiling is continued. It's a routine practice that is happening in Victoria, and that policy and the anti-racial profiling policy is meaningless. It's a piece of paper in the Victoria Police Manual that is not being monitored, it's not being checked on, it's not being enforced in any way. So that's right. What we see here is this really clear example of the reactive spin that the police agency goes into when there's kind of litigation. It doesn't actually there's no deep down integration of those ideas into everyday policing practices. And I think this is really critical when we've just heard the Chief Commissioner on the 8th of May making an apology to First Nations people and promising that he and the police will review all of their practices and operations to ensure that they do not systemically disadvantage First Nations communities. So we've got this kind of really great statement from the police, but we need to be super alert to the ongoing failure of the police to actually do anything to implement those high ideals that they're suggesting. So it really, I have to hear that even though that was a wonderful apology and, I'm sure it brought tears to so many people's eyes, it's just to finally have the police admitting systemic racism it's just so amazing that they did that. But there's that immediately the cynicism rises up based on this history that actually, no, what are you really going to do? So I think, we need to really question how realistic, how sincere that apology is actually going to be in practice.
And in case people have just tuned in, this is the Doing Time Show, 3CR Community Radio, and you are hearing an interview with Tamar Hopkins, who's talking about a thesis about racial profiling in Australia.
Leaps and Bounds Music Festival is warming up winter in Yarra. Don't miss the Archie Roach Foundation presenting Singing Our Futures, a fundraiser with Emma Donovan, Kiwat Cannell and Kian at the Corner Hotel. Explore the program by visiting the website lbmf.com.au. Leaps and Bounds, 13th to 16th of July. Yarra City Council is a 3CR supporter.
See what I want to think and now's the time to grab it. I'll make change.
Smith Street Dreaming is a special gathering of dancers and musicians that will honour elders, families and community through traditional ceremony in Fitzroy. Featuring Uncle Herb Patton, Auntie Janice Bakes, Jiri Jiri Dance Group, Murundaya Yapenya Dance Troupe, Bandok Tati, the Small Ant Brothers, Uncle Johnny Lovett, Lee Sunnyboy Morgan Show, Empath Soul and Firestarter Chris Hume. In Atherton Gardens, corner of Brunswick and Gertrude Streets, Fitzroy. Saturday, July 15th from 1 till 5 p.m, with free barbecue and coffee on site and entry is free. Smith Street Dreaming is supported by the Victorian Government through Creative Victoria, the Smith Street Working Group, Leaps and Bounds Music Festival and Yarra City Council, a 3CR supporter.
Sunrise from polluted seas, fishing in the rivers full of blue algae, breathing this air here could kill old mania, the whole earth becoming a huge gas chamber. Just wanna know which side you stand, for the dirty dollar or the pristine land. Just wanna know which side you stand, for that dirty dollar or the pristine world products in third world hands, forcing monoculture into starving hands, executing and jailing those who say it's unfree, rich importing their wealth, exporting poverty, rich importing their wealth, exporting poverty. Just wanna know which side you stand for that dirty dollar or the pristine land. Just wanna know which side you stand for that dirty dollar or the pristine land. Dirty dollar or the pristine land. It's so good for the economy. 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 It's so good for the economy.
It will not address the deep underlying issues that still pervade Australian society. And that primary issue is white Australian racism.
We've got a clear-cut case here of intentional genocide from the get-go, from the Round Table in England.
The true history in this country isn't told. The government always say that they're committed to a truth-telling process. Well, where is your truth-telling process?
I really believe that at the end of the day, the truth will emerge. You can't fight against the truth. It's an unstoppable force. It's indestructible. So deal with it.
3CR. Stay tuned, stay radical. "3CR. Stay tuned, stay radical."
We demand the full restoration of all Indigenous lands and resources, and we demand the immediate cessation of all forms of exploitation and destruction of our land.
We're here to remind you of our sovereignty and our original demands from day one.
It started with intentional genocide of our people around the Round Table in England. It's all lies here. Everything's a lie. It's a great opportunity right now. Step into a sovereign, independent republic.
We demand a treaty. We demand our lands back. We demand to stop Black Death in custody.
You're listening to the Doin' Time Show, returning now to an interview with Tamar Hopkins, speaking about her thesis, Understanding Racial Profiling in Australia.
Yep.
So the purpose of the thesis is not to tell racialised people what they already know. The thesis is for scholars, policymakers, legislators, lawyers and courts. Can you talk about the strategy for making racism in policing visible?
Yeah. So there were a couple of strategies that I undertook to make racial profiling visible. So the first one was to actually collect and obtain data on the problem. So that's a really critical strategy, to have this data now available, to be able to provide this data, and I was able to provide this data to UROC on the 2nd of May. Here is data that shows racialised people, First Nations including, are being treated in this really different way. So that's a really clear aim of this thesis, is to make it visible for policymakers in that way. But the second, another aim was to really start the process of shifting the way our courts deal with racial profiling. And so what I was able to do in this process, and I guess I've been aware of this from running cases in Victoria, that a lot of the most important case law on racial profiling actually comes out of Canada. So I was really interested to know, well, what's going on in Canada, and what is it about Canadian, like the Canadian legal system, that is producing, really good, important case law on racial profiling? Because Canada and Australia are quite similar spaces. We're both multicultural countries with unresolved colonial histories, brutality on invasion, and it's ongoing issues of racial profiling and issues around race. So it should be really we both have our legal systems are based and arise from common law, which comes out of the UK. And so why is it that Canada is going so far and we in Australia are not? And people often say, oh, well, it's because Canada has this great charter of human rights, but the reality is it's not about that, because, we now have a Charter of Human Rights in Victoria, and there is one in the ACT, and just more recently in Queensland, and none of these charters have meant that there's been a jurisprudence about racial profiling being developed in these spaces. So there's something really different. And the other thing is that we've got, there's a human rights charter in Act in the UK, and yet the UK is very poor on racial profiling case law. It's just not really developed there at all. So there's something kind of really different about what's happening in Canada. And so what I did was have a look at, what is happening. And I guess I can really just speculate into why these differences are happening. But one of them could be that in Canada, lawyers they don't have a split profession. So if you're acting for your client, you get your instruction from your client, and then you go in and you make the arguments in court. You don't have to convince your barrister to make the arguments in court like in the UK and Australia. And here we've got barristers who kind of have expertise in trials and aren't necessarily as attuned to their client's experience as solicitors may be. So that's just one potential thing that you have. Yeah. This kind of one person who's acting. But the other thing is that I guess there's, a lot more racialised judges and lawyers in Canada than there are in Australia and the UK. So that could be part of it. But yeah, there's just been this kind of incredible understanding, a real kind of deep understanding of the way racism manifests in the criminal justice system. The criminal legal system in Canada that just we haven't even tasted here. We don't even understand. The language doesn't even appear in our cases. We have it in the Royal Commission into Aboriginal Deaths in Custody and kind of occasional cases, but really it's missing in so much of our criminal case law. So what was interesting in Canada is that they were actually drawing on UK decisions and interpreting them in ways that we just have failed to interpret in Australia. So they have they've interpreted this idea called an investigative search. An investigative stop. So in Canada, if the police stop someone to ask them questions, they need to have reasonable grounds to connect that person to an actual offence before they're allowed to do that investigative stop of that person. Whereas here in Australia, it's really muddy and there's not a lot of case law that would limit the police from being able to do that. So they've created much more rigid boundaries around police powers, clearer thresholds, and they have, so they've got more restrictive common law that prevents police from just engaging with whoever they want on the street, but also a much deeper understanding of the way systemic racism operates, and courts will take into account histories of racism, will take into account kind of localised knowledge about what is going on to frame encounters between police and racialised people. So they kind of allow that lens. And in fact, they say not only should you allow, should you take that into account, but you must take that into account, because you can't actually judge the credibility of a police officer interacting with a minority person unless you understand the whole racialised history and context of that area. And so that's kind of like that's where I really want to see Australian lawyers kind of really understanding, taking that on board, starting to kind of use arguments to build in the context of racism into their cases, and also to start to use this data that now exists to show that, to provide information about the racial context of all police encounters with minority people. So that's the second strategy to make racism visible, is by getting Australian courts and lawyers to start talking and arguing about this issue.
So, in case we've got new listeners that have tuned in that don't really know what racial profiling is, are you able to document or to speak about, an example of racial profiling?
Yeah.
Or a case, or someone that it's happened to, just so that we can make it clear? Yeah,
sure. So there's a good example that is the Carver case. It's the case where the police were driving along and pulled over these. So there were a couple of African young people in a car driving in one direction down the street, and the police were driving in the other direction down the street. And they decided to pull up that, do a big U-turn, come in behind them, pursue them for a bit, put on the lights and pull them over for a routine intercept. And so when they did this routine intercept of this car, they then got out, asked the passenger for his details, his name. He refused to give them his name. They asked again. He refused again. They asked again. He refused again. And he got out of the car, and an altercation happened between the police and the passenger. And there was also a situation. The police asked to search the car by consent. So they asked the driver if they could search the car. So what we have here is the police are claiming that this is just a routine intercept, and the police are allowed to do these routine intercepts for two reasons. So they can do them for licence and registration checks, and they can do them for preliminary drug and alcohol checks. So they didn't do a preliminary drug and alcohol check on the driver, and their questioning of the passenger and request to do a search of the vehicle demonstrates that they were not, that wasn't actually the purpose. Their purpose wasn't to do this routine intercept. This was actually, they wanted to question the passenger and the driver to, it was a broader, it was an investigative stop. It was a proactive stop. And so in this case, it's the police never used racial terms here. However, the driver and passenger were clear that they were being racially profiled, and that there was no, this whole thing was just an attempt to harass them. And so the question is, how do in the absence of the police going, yes, I stopped this person because of their race, how do we in Australia or anywhere, say that actually this was racial profiling? And so what we can do here now is that we've got this data that shows that these random intercepts are actually far more likely to be experienced by African people and white people, and also that this kind of unjustified post-stop experience that was experienced by the passengers in the car is much more likely to be experienced by racialised people and white people. So we've got that, and then if we understand, so in the Canadian case law tells us that racial profiling will never be, we will never prove it through admission by a police officer. What we need to do is understand whether the circumstances of the stop correspond to the phenomena of racial profiling. So we need to understand what is the phenomena of racial profiling. And the phenomena of racial profiling is understood by the fact that these kinds of stops happen much more likely to African people. And you need to understand that this stop occurred in a whole context of complaints being made by the African community about over-policing. There's been this big, racial profiling claim in Victoria. And so when you kind of take all of that sort of social context into perspective, into account, and understand the data, you can start to say, yes, this was stop, that was racial profiling. This experience, race was a factor here.
Absolutely.
And our Race Discrimination Act says that race doesn't need to be the only factor behind the stop. So long as race was a factor, it doesn't even have to be the dominant or substantial factor behind the police treatment. It has to be just a factor. So if race was a factor in why the police pulled over these two African young people, then that is racial discrimination under Australian law, and that evidence should be excluded. So in this case, the Carver case, it was an exclusion of evidence case. Asking that the court to not take into account whatever happened after the stop, because the stop and the treatment of these young people was based on, was improper.
Absolutely. Tamar, thank you. Look, that was a really concise example, and I really appreciate that. I think I'm going to have to finish pretty soon, but let's just quickly, can you just let listeners know where this thesis can be read? There is a public version out there?
Yep, that's right. So if people put into Google my name, Tamar Hopkins, and Understanding Racial Profiling in Australia is the name of the thesis, then they will be able to, they'll go straight to a site where they can download a PDF version of that PhD. Yeah.
Any final comments?
I guess just watch this space because, this is not a story that is disappearing, as everyone knows. So, there'll be more to talk about soon.
Wonderful. Tamar, thank you so much. It was lovely to have you. I mean, I really wanted to, my intention for the Doing Time show was to have a 2-part series with you. And this is our second interview, so I'm hoping that we can have a lot more education about racial profiling, that the police are held to account. We can't have police investigating police.
Absolutely. You're so right, Marissa. Thank you very much for this
Thanks
opportunity.
a lot. Thank you very much. We'll talk soon.
Okay.
Thank you. Bye-bye.
Bye.
And that was Tamar Hopkins, and Tamar has just finished speaking about a thesis about understanding racial profiling in Australia. And we're nearing the end of our show, and we're going to be going out now pretty soon with our theme song, Black Fella, White Fella by the Rumpy Band. And it's goodbye from Marissa. Stay tuned every Monday from 4 to 5 for the Doing Time show. And as Tamar says, watch this space and be kind to each other. Bye.
You've been listening to a 3CR podcast produced in the studios of independent community radio station 3CR in Melbourne, Australia. For more information, go to allthews.3cr.org.au.
As long as you are true fella, as long as you are real fella. All the people of different races with different lives in different places. It doesn't matter what your name is. We got to have lots of changes. We need more brothers if we're to make it. We need more sisters if we're to save it. Are you the one who's gonna stand up and be counted? Are you the one who's gonna be there when we're shouting? Are you the one who's always ready with a helping hand?
sisters.